I'm here once again with Dr Elaine Freer at 5 Paper Buildings, speaking with her about ancillary orders in criminal courts. Elaine, I wondered if you could tell us what makes working with ancillary orders challenging in practice.
I think probably their huge availability. There are lots of different ancillary orders. A lot of them have different threshold criteria, so there are some that can only be obtained after someone's been convicted. There is one order that can be obtained where someone's been acquitted, which is a restraining order on acquittal. And there are also orders that can be sought by the police or other agencies where there may not have been a conviction, but where there's some good reason to think that an order would be appropriate. So there's a vast number of orders. There will probably be more added to the list over time. And a lot of them are quite complex. They contain various clauses and subclauses which impact the operation of the order and when it's available. And it's very difficult to hold in your head all of the relevant legislation and case law about the whole range of ancillary orders. For example, just to show how widely they can apply, if you've got a case of dangerous driving where a defendant drives their car off the road and into someone's garden fence, a very simple offence, sort of thing that the magistrates deal with all the time. But in terms of ancillary orders, you're looking at a potential disqualification from driving, compensation for the owner of the fence. And if you imagine that when the police searched the car, they found a small amount of drugs, there might then be an order for forfeiture of the drugs. So really straightforward set of facts, but already you've got 3 ancillary orders that the Crown are likely to be applying for. And in order to get the best result for your client, if you were defending, you'd need to be able to confidently navigate all 3 of those and make submissions to the judge about what should or shouldn't be done in each case, the amount of compensation to be awarded, whether the drug should be forfeited, is a disqualification necessary, are there any exceptional circumstances that mean your client might escape disqualification, exceptional hardship, for example. So there's a lot to be considered even in what seems like a fairly run-of-the-mill case.
Yeah, so vast complexities even in the simplest of cases.
Yeah.
And obviously we're here today because you've written a book, a practical guide for those using them. What do you think someone might gain who's looking at such a situation? What would they gain from flicking through some of the chapters that you've provided?
I hope they would be able to access the information that they needed quickly, so not have to go to an overarching text which might contain lots of different things, but it might then be hard to find the precise thing they want. But they could go to a book that's only about ancillary orders and find what they needed quickly, find the legislation and case law, so they could see what the current state of law was and then best pitch their submissions to the tribunal.
And that's in terms of if they wanted to do general reading, but also they're in court, they've got 10 minutes, it's something that they can access in that time.
Yes.
As well. Okay, great. Thanks for explaining that to us.